had like the long established regulation on personal data protection, and we know that the regulation is being a benchmark for many countries in regulating personal data protection. And also, as we know, that Indonesia has also enacted the personal data protection in 2022. But then we still wait and see, like from the government, the further action of the implementation of this personal data protection law. And this afternoon, we will discuss deeper on this issue. And we already had like four distinguished speakers that are coming from the UK and also like Indonesia. And but before we start our international seminar, there are several things that I really want to share the information to all of the participants. First of all, we really want to say thank you and extend our gratitude that you guys are coming in this international seminar. And we hope that you will be here until the next 2 hours. And this international seminar will be held in English. But then, if you want to follow this international seminar easily, you can turn on the closed caption feature. Let's look at it below the Zoom application. That is the icon of CC. You can click that and then like choose the English, and then the subtitle of this seminar and also international conference will be shown there. And other than that, for the Q&A session, we have like the Q&A box in this Zoom application. The participant can use that feature along the international seminar. So you can drop down your question there, and as a moderator, I will be try to like filter the question, and also like will be deliver that in the Q&A session. And because I haven't introduced myself, I'm Chevy, the moderator as well as the researcher at the Indonesian Institute for Independent Judiciary, or well known as LeIP. Our work mainly on the issue of the judicial and also like legal reform. But for the past years, we have also like focused on the issue of the intersection of personal data protection and broadly for the context of the technology and also legal and human rights. And there is some guidelines, guys, and also there is the virtual background that is already sent by the committee in the WhatsApp group, so you guys can access that. And please be mindful with that guideline. And because we really respect your personal data, we encourage you to open the camera if you are willing to, and if there is no issue with the internet connection, also with the personal data issue, we encourage you to open. But then if that is the issue of those things, you can just like off the camera. That's totally fine. And also we will like record this international seminar for the purpose of like the documentation and also the archive. So we will record this, and also we'll capture some of the pictures along the international seminar. So if there is an issue with that, the participant can tell the committee so we can take action on that. Thank you so much for that. And yes, and maybe once again, we really want to say thank you for your presence in this international seminar. And without further ado, I really want to invite the executive chairman of the Paham Hukum, Boy Crescendo Sitomorang, to give the keynote speech and opening remarks for this. So I give the screen to Boy. Time is yours, Boy.
Thank you, Shafira dan Madia. Ladies and gentlemen, brothers and sisters, and all the people here, to start our meeting, to start my keynote speaking, I would like to address some question for all of you. Have you ever experienced that out of nowhere, you receive a message from one company or from the government or anything else, then they do marketing and even keep calling you? The second question, do you feel comfortable with that? Or have you ever thought where the research that they get your number? And the last question, more, have you even thought the serious impact of it? Or what's the price of it? Ladies and gentlemen, brothers and sisters, welcome to Paham Hukum International Conference. I am Boy Crescendo Situmorang, a legal practitioner in Indonesia. In today's session, we are talking about personal data protection law. And that's actually a very crucial issue in Indonesia. Those three questions will describe what's actually happened in Indonesia. Talking to this topic, we can refer to Indonesia enactment of law number 27 of 2022 concerning personal data protection marks a significant step towards strengthening the protection of personal data for Indonesian citizens. However, implementing this law presents various challenges that the government must overcome. If you talk to this issue, basically, laws are made by and for humans. Then the logic consequence is the law must be able to cover the legal needs of human up to the phenomena that occur in the society in every legal regime. This also applies to the protection of personal data, which is developing very massively in line with the digital era and freedom era. In this era, we are facing so many information. We are facing so many, disruption and so many cases in our society. So that's why we need personal data protection law. In Indonesia, for example, recently, the public was shocked by the hacking case of the National Data Center. The Ministry of Communication and Information, as the manager of that National Data Center, stated that the hacking had occurred since June 2024. Obviously, it concludes the citizen personal data, which should be protected. Along with that, data protection law is concerned with a great deal more than safeguarding simply the privacy of individuals. From my perspective, it serves a multiplicity of other interests as well, such as democracy, talking about the pluralism, information quality, etc. This interest can attack to collective entities in addition to individuals, and even to data controllers as well as data subjects. In my opinion, talking about the personal data protection law, still there are so many challenges facing by the government and also the society itself. At the first time, the government must create implementing regulation, because actually we have already had existing a law about it, but we should regulate the specific thing in this matter. Even ensuring the existence of personal data protection bodies and technical implementation of prevention and law enforcement related to personal data protection. The second one, in a specific, we should have a significant effort and cost required to implement the personal data protection law, especially if it should be involving private and corporate sector that may have benefited from the lack of data protection regulation. With the big possibilities, they won't support it, but the state, the government should regulate it. The other challenges we are facing is to ensuring compliance from the company and the public bodies. In my opinion, also, it's crucial to prevent data misuse and leakage for profit-driven purposes. Because in daily life, we often collect our data while using the public services by the government or private sector. So we also should take care about that data usage. Since Indonesia have a culture inclination towards collective society and a lesser emphasis on the privacy, there is a risk of unintentional violence due to lack of awareness. So it's really required to fostering a public understanding of the regulation even in their every daily activities. To make it holistic, ensuring educational initiative to raise awareness among all levels of society is essential to mitigate this rate. So we will And we must work together with the government, with the society, how the government can regulate it, and also how can we have awareness to support the implementation of that law. In this occasion, I would like to extend my gratitude, my massive appreciation for Paham Hukum, who initiate and organize this great work with the collaboration with LeIP and all the speakers from each institution. We will hear from the government perspective delivered by Ms. Indriya Swati, Ph.D. from the Ministry of Communication and Digital of the Republic of Indonesia. Also, we will hear from the academic perspective from Dr.Iur Yuliana from Unika Atmajaya University. And also, we will hear the update from the speaker coming from University of Southampton in United Kingdom. As a comparison study, we can, like compare it and also learn about it, keep sharing anything, the best practices in there. To conclude this keynote speaking, I would like to say data protection is the right part of human right. It's talking about ourselves, our life, our surrounding, even our privacy. As law made for human, so we need and we should ensure the law itself cover the concern with all form of legal protection, even legal guarantees. Thank you.
Thank you so much for the keynote speech, Boy Gerson Situmorang, the executive chairman of Paham Hukum. And the last sentence is very interesting because, like, you say that personal data protection is a part of human rights. And yes, that is the part of the right to privacy. So it's very important for us to respect this and also to, as a subject data, which is all of us as subject data, have some rights under this personal data protection law. And it's very important to discuss this. And thank you so much, Boy, once again for that, because like you have already highlighted some of the important things from the Indonesian side and also from the global, maybe like some of the global perspective on that. And yes, after this, we will hear the presentation from speakers from Indonesia and also from the UK. But first thing first, we really want to invite Bu Indriya Swati Saptaningrum, which is the expert staff of the ComDG or the Ministry of Communication and Digitalization. But as a context, Bu Indri is also the part of civil society organizations. She has been working a lot, like many years, together with the civil society organizations. So by this chance, we expect to hear from Bu Indri at least because like Bu Indri now is the part of the ComDG. We really want to hear like how is the update from the ComDG regarding like the challenges to implement this personal data protection law. And other than that, we also expect to hear like the roadmap maybe for the implementation of the personal data protection law. But if there is something important to share to this, please do share, Bu Indri. So the time is yours, Bu Indri.
Thank you so much, Sevi, for inviting me to this very important. Does my voice can be heard clearly?
Yes, we can hear your voice clearly.
Okay, sure. Okay. Allow me to share some of my update on this. Let me do this. Uh, yeah. First of all, I would like to thank you for Sevi and Paham Hukum to invite me into this very important international conference. Yes, at the moment, I'm actually the expert staff to the Vice Minister of Communication and Digital, previously known as Ministry of Communication and Informatics. So we noticed that there is a different uh, scope and responsibility introduced into this ministry to expand the authority into the so-called digital ecosystem regulations. And for these occasions, I would like to share some of the insight that we've been actually me as a lecturer at the Atmajaya University in law and technology, as well as my work with the vice minister in uh, in preparing or the involved in two different key area at the moment. First is try to help and work the vice minister in preparing the regulation related to the emerging technology, including AI. At the moment, I'm part of the uh, member of the task force on national roadmap AI for Indonesia. So Indonesia National Strategy, AI National Strategies, uh, which is at the final stage of the finalization of the document to be attached into the proposal into the presidential regulation on AI in Indonesia, expected to be issued by August this year. So this is an important year for us because not only about the PDP, which is one of the pillar in the regulations of AI, the upcoming regulation of AI, but also in terms of the implementation of the personal data protection, this is also a critical time because the long-awaited implementing regulation is actually also expected to be issued within the first semester of this year. So, as we also see that these two different regulations will be actually can be a game changer in the landscape of personal data governance as well as a digital ecosystem in Indonesia, especially in regard to the emerging tech and the rapid adoption of AI in Indonesia. So I'm gonna start because the point asked to me is try to share the insight within the ministry on what is going on with the long-awaited implementing regulations on PDP. But of course, we thought touch upon a bit about the context. I believe Ibu Yuli will go through it in more detail. Perhaps it may not be make sense to talk about the implementing regulation itself. So I'm going to start a bit with the context. Why is it the implementing regulation is the things in we direly need in ensuring a stronger protection for personal data in Indonesia. Uh, I can simply start by looking into the landscape of or digital landscape of Indonesia. As you can see from the screen, we are now having around 280 million populations, and out of it, there are 356 million mobile phones circulated among the population. So from this piece of data itself, we can see that the connection and the traffic of internet and the connection of people online can be expected to be increasing because of the increased number of mobile phone, and because of that as well, we've learned that from the personal data point of view, there is huge challenges in looking into how and the strategy to create a stronger protection when it comes to smartphone use and smartphone devices and mobile connections rather than fixed connection to the internet, because it's then might touch upon partially into the issues of digital security I would like to discuss later on in these presentations. Secondly, when it comes to the context, it is also good to consider the landscape of social media use in the countries. I put it in the right hand side of the screen, and you can see that social media is very popular in Indonesia. Almost 97% of smart devices user were actually active social media users. And if we combine this with the durations of people going online, then it gives us a good kind of like landscape on why is it so important to have a stronger mechanism in place in protecting personal data protections. Because according to this report issued by Via Socials, a company based in Singaporean that regularly issued annual data about digital landscape of Indonesia, we've learned that people were actually connected online on the average of 4 hours up to 7 hours a day across different age variations. And a little note on that is also important to learn that 10 million children are now actually actively going online through a different smart devices. Most of them were actually mobile phone or cellular based connections. So with that, I would like to move into why then law number 27 2020 is important for Indonesians digital landscape. First of all, I could actually pinpoint two key issues or two key points that I think is fundamentally changes the landscape of data governance in Indonesia. First is about introduction of legal definitions and introduction of legal foundation to regulate the three different object or subject of the law, which is data subject, data processor, and data controller, as well as the establishment of independent body to see the enforcement of the law. So on this, I believe that the next the next speaker can touch upon into more detail on a detailed provision provided by the law. But this has changed and also followed by key provisions on personal data governance that introduce and that actually strengthen the protection of personal data in Indonesia. For example, it introduced the legal requirement for data processing. So to be able to be legally process personal data, there are several key requirements that need to be complied to, as well as underpinning principles in data processing, cross-border data transfer, among others, are key provisions that actually then now apply to all citizens in Indonesia, be it as a data processor or data controller or as a data subject. And among others, also it laid down provisions and legal obligations to ensure cooperation among stakeholders to make sure that the protection are there for personal data, as well as public participations to ensure inclusive uh, engagement among different actors within and being regulated by law. Among other things, we've learned that several issues has been becoming and still becoming a key public debate up to today, including the authority of the body, the sanction, especially the criminal sanction and the amount of fines applied for any violations, as well as transition period put forward by the law, which is overdue at the moment. So with that, key fundamental things that support my statement is at least described in this PowerPoint in this page. I will not go one by one due to the limited of time, but the underpinning was there is a shifting paradigm in terms of how people perceive and how people treat personal data. And the shifting of paradigm is not something easy, both for the public, for the government official, for the corporation, as well as for the data subject themselves. And this actually link into some key challenges that I would like to draw upon your attention to when it comes to the implementation of the law. So, in a nutshell, some of the key challenges in the implementation of the law can be described in this 6 point. I believe this is not something, what do you call it? exhausted, but the list can go on and on. I try to pinpoint 6 different aspects that some of them has actually been touched upon by the keynote speaker in the beginning of this event. So, but things not there that I think is very important to be considered is on the left side, I put the situation in which the rapid adoption of new emerging tech is actually ongoing at the moment. By saying that the challenges is because we cannot stop these adoptions because it's actually something from my perspective is something inevitable within the ecosystem, digital ecosystem at the moment. For example, the use of the introduction of IoT, which is gradually increasing, the acceptance of AI and the use of AI both for the end user as well as for the data processor and data controller in supporting the applications and providing a more seamless experience for the users. This become a challenge because we haven't had a strong pillar in the enforcement of personal data as well as data governance at the moment because of the delay in the issuance of the implementing regulation of the PDP law. The second issues which I think become major challenges is coming from the fact that digital literacy is still a problem for us, in which public awareness of personal data is, I know it's increasingly, gradually increasing, yet it's not adequate to catch up to the pace of tech adoptions. So, and this lead into a critical situation in which increase the risk of digital security as well as breaches of personal data uses as well as personal data processing. So this is the issues that I think not only the responsible of the government side, but different stakeholders will actually contribute and is actually are expected to contribute to also address this problem. Another key major challenges is in regard to the lack of digital infrastructure. The landscape of digital ecosystem I put at the first slide can actually provide an illustration the extent to which digital infrastructure become a main major issues, because by looking into that first learn that major connect why people into that connection devices, because the fixed more stable digital infrastructure were not in place at the moment, despite the fact that the government has actually finished completing the project of the second phase of Palapa. Most of the eastern part of implementations of that and the result of that infrastructure and provide adequate connections of internet in the countries. Into the readiness of private sector, I see that we have a huge small medium enterprises that contribute 61% of the PDB. So SMEs is a key actor in Indonesian economy, in which 24 million of them were now actually connected into digital ecosystem. And actually the government through their president priorities program included the action to actually promote a more and increase and speed up digital inclusions of SMEs into digital economy ecosystem. So with this, the very question and challenges is the extent to which they were actually ready to comply with the PDP, because the enactment of the PDP in one side introduce a new requirement and a new standard in data processing, and including those carried out by these SMEs. So that's another key issues that we need to think about it, and how we can actually anticipate, because in the keynote speech, it is also discussed that data leak is one of the major potential issue that can repeatedly happen and has direct impact into the protection of personal data. But the fifth challenges I see is the rapid integration of public services into digital ecosystem due to the government's, attempt to transform digitally all the public services online. And this, as mentioned in the keynote speech as well, that there are several different layer of challenges from the culture within the bodies, as well as into the readiness in terms of digital infrastructure to ensure that they have a strong digital security in place in processing citizens' data, including the issue of silo implementation, because we are dealing with hundreds of applications introduced by different government bodies, including ministries, that sometimes do not interoperate each other. And this actually promote more data collections of personal data, which is against the principle guaranteed by the as mentioned before, is about the incidence of data breach because of different combination of different challenges we are having. So to close the insight, I would like to is a roadmap of implementations. Despite the need of the roadmap, the delay in the issuance of the regulation on PDP law actually contribute to the continuation of the absence of such roadmap. Why is it so? Because ideally the roadmap is part of the commission's work, and that is expected to be the solely institution being independent from the government and the third party to oversee and to actually nurture and fostering the implementation of the law. So if you learn from the neighbor country like the Philippines, it may take 4 years only to make the countries ready with all the soft and hard infrastructure needed to implement the law. But the priority, one of the highest priority for Indonesia, I think, despite the fact that we haven't had the commissions, is the harmonization of laws and implementing regulations. So that because although the law provide transitional period, according to Indonesian legal system, the norm of the law is actually being applied on the day the law is enacted. So in that sense, it is the responsibility of different government institutions to again work rapidly or immediately to look into the need for harmonization of the law so as to provide a more universal standard for data processing, especially to strengthen the data protections that collected and processed by the government agencies. So in that, I think what happened now is the market and the digital ecosystem are actually learn and try to use the available best practices, mostly by industry, introduced in the ecosystem, be it because of the interaction with different legal regimes, such as the EU GDPR as well as the US standard in terms of protecting data protections. So I think I end up this. I hope I do not go over the time. And hopefully this can provide a good introductory discussions into a more substantive, go through into detail of the law on the PDP and a comparative perspective on PDP protection across different countries. Thank you, Zevi.
Thank you, Bu Indri, for the update, for the information regarding like how's the challenges regarding this implementation, also the roadmap. And we can see like in the chat there are already like few comments and also few questions for you. So maybe like we can discuss further in the Q&A session. Thank you so much, Bu Indri, for the presentation. And because Bu Indri has already mentioned like there will be like Bu Yuli that will explain more on this Indonesian contact. So I invite Bu Yuli, Bu Sih Yuliana Wahyuning Tias. She is an academician in the Unika Atmajaya, Jakarta. And Bu Yuli has already active like for how long, Bu Yuli? Like maybe like the past 10 years, or for how long you've already active in this discussion?
Yeah, more or less.
More or less, yes,
Yeah.
yeah. And since the discussion of the personal data protection law, Bu Yuli has been very active. And after the enactment of the personal data protection, Bu Yuli has also contributed to many discussion of the derivative regulation, of the implementation, not only from the academician side, but also like from the civil society side, because like Bu Yuli also have many chance to also talk with the civil society organizations. So Bu Yuli, we expect to hear from you like how is the maybe like the notes or the criticism for the personal data protection law, because we knew that there are some of the problematic provisions maybe, or not so problematic, but like maybe Bu Yuli can share on that, and also like how is the challenges of this implementation from the POV of the academician, also like the public in general. So Bu Yuli, the time is yours.
Thank you very much, Mbak Fira. Also, thank you, Pak Boy. Really, really appreciate the invitation. It's really an honor for me to be able to share my thoughts here. And I'd like to share some thoughts, maybe some ideas about what's going on after the enactment of the Personal Data Protection Act in Indonesia of 2022, and continuing what Ibu Indri has discussed in the previous presentation. I would like to go further, but as Mbak Fira, Mbak Shefi, I'm sorry, as Mbak Shefi mentioned, I will share from the perspective of academician. So this is more an update, and I would like to share some maybe some major points, critical points that I would like to draw your attention to. So with this enactment of the Personal Data Protection Act of 2022, that has been normatively, effectively enforced in 2024, so 2 years after the enactment. As Ibu Indri said, it applies already right away after the enactment, but the law gives a window time for the transition, for an adjustment, for us to adopt our behaviors, of course, to the new law. And we had 2 years time until 2024. And now, where are we? This is what I would like to share with you. I understand that I have 10-minute time to share my thought. So, Mbak Shefi, please kindly be free to let me know if my time is up. Thank you in advance. The first thing that I would like to address is awareness. So I would like to say from the more positive attitude towards the enactment or the law itself, the PDPA, I would call it. It is actually a good starting point for us in Indonesia to have this awareness of the importance of protecting personal data. So the importance of personal data itself, and then the importance of protecting it. I remember those days, Mbak Shefi, I'm sorry. I just had a discussion with a person called Mbak, so I'm sorry, Mbak Shefi. So as Mbak Shefi mentioned earlier about how long I've been involved in this matter, in this discussion. So I can remember when we started, when I jumped in the discussion in Indonesia, after I come back in 2015 to Jakarta, to Indonesia, I remember how not easy it was to make the audience understand why data protection is important, why we need to protect our personal data. And it is really wonderful to see how it changed over time, and then we also adjust the way we behave, the way we make our decision, the way we see things. So with this enactment, the enactment of the PDPA, this is actually a very good starting point, that we have something that we can normatively rely on. So normatively and ideally, yeah. So this is from the more positive viewpoint. And I also have some research going on with my team, and we keep talking with the stakeholders about the law, about how they see the law, how the industry see the law, how data subject sees the law, and what we see is that they appreciate that now Indonesia has this law. And from there, we can move to compliance, because compliance will not be there without awareness. Well, it can be there with a solid enforcement, even without awareness, maybe, but still, awareness is very important for compliance. And from there on, it's also interesting to see that we have more studies, more discussions, and I think several weeks ago we had also a discussion with Mbak Shefi and team about how data protection interact with public information. So how the protection of personal data should be balanced out with the interest or the public interest. And this is a very good example on how we evolve from not really recognizing our rights to have personal data protection to deeper studies, deeper understanding about how this right should be or could be exercised in a very specific ways, or in specific issues, and even in very technical matters. So this is a good thing. Awareness, building awareness, raising awareness, but of course, the problem is that we need to see more of actions of how the government improve or building this awareness, because we have seen many actions taken by civil society, by the industries, independently, also by academicians, but we need to see more action from the government about how people can have a higher awareness about personal data protection. And this brings me to the second point that I'd like to address in my presentation, is that with the development until today, we can see, unfortunately, the lacking of guidance. So we see that technical guidance is still missing, and unfortunately, this is in important or major aspects of the law itself. So it seems that we have really a lot of homeworks to do in the future, well, today and ahead, yeah. And it also means that we need more, well, we need implementing regulations. It can be in the form of government regulation because this is what is mandated by the law, but it can be also in other forms. And even it can be in the form of guidelines, but the problem is that we still don't have the institution, so-called the Data Protection Supervisory Authority, who theoretically, ideally, would be able to draw these guidelines and help us to implement the law. And this missing technical guidance we can see in different aspects. But if I have to mention several examples, we can see this in the topic of data transfer, data sharing. Well, particularly if we talk about data transfer, and then we deal with international data transfer, yeah, because if it's within a national jurisdiction, maybe it's less problematic because we are subject to the same law. And then we have also need to have this technical guidance, the implementing regulations regarding joint controllers, regarding child protection, and even about exemption. And this then brings me to the third point of my presentation, that under the current Personal Data Protection Act, we unfortunately have a too broad scope of exemption. So basically, we have exemptions that and the PDPA says that this exemption apply only when the exempted object is regulated under law. But that's it. And we do not have a clear limitation or a clear scope in how the exemptions would be implemented, and also how data protection remain protected while the exemptions apply. Yeah, so these two broad exemptions, in my opinion, it's not a good approach, because if we have two broad exemptions, then well, if it's broader than the law itself, then this is not exemption, actually. Well, from theoretical point of view, of course. And then, on the other hand, the exemptions are broad, but on the other hand, it doesn't sufficiently cover what is necessary for an exemption. This can be seen in the issue of data processing for journalistic purposes. In our PDPA, there is no provision providing exemption for this type of data processing. So there's no exemption, say, for journalists. So this is something that also need to be looked into more, well, mostly by the government, and we need to clarify this in how to implementation this exemption, and also to cover what has not been covered in the exemption. And talking about this, I'm sorry. Then I go to the fourth part of my comments about our performance in protecting personal data in Indonesia, namely the implementation. So, good news is that the PDPA applies for not only private, but also public sector. So it applies for both. That's a good news. I mean, private and public as data controllers and processors. However, we can see that so far we still have issue in how the public sector complies to the law. And this brings also to the next issue about the enforcement. If the compliance is lacking, then how it is enforced in reality? Because so far we see, as Pak Boy also mentioned in his keynote speech, that we still have from time to time problems with data leaks, and this connects to data protection, data processing by public data controllers. But so far, we are not sufficiently happy with the ending of the story. So I think this is something that we also need to work on. Another issue with implementation is that we need further guidance on how we facilitate the micro, small, and medium enterprises to comply with the law. So the idea is that the PDPA exists not to punish people. That's not the idea. The idea is to help people to protect data protection. That means that education matters, building awareness matters, facilitating small scale of data controllers matter, not small in the sense of the data being processed but small in the sense of the economic scale or business scale of the companies, because compliance means also cost for businesses, and it means that support is necessary for small businesses to comply with the law. The next issue that I would like to address is about the protection of specific or sensitive data that already is protected under the law, for example, the biometric data. But what we have seen so far until today, that we have even more massive use and processing of this type of data without clear protection. It seems that there is no really significant differences between the situation in where the PDPA exists and not. So this is something also that that should be taken into account. And another issue with this is the compliance monitoring. Well, the compliance monitoring requires certain institution that would be responsible for the monitoring up to imposing sanction. But as I mentioned also earlier, we still don't have the law. And this brings us to the next issue about enforcement aspects of PDPA. First of all, is data protection supervisory authority is still missing, or we still don't have it. This is problematic because then we rely on two channels for enforcement. Well, three channels. One is the channel through private claim procedures, but we have also problem with this because traditionally, conventionally in Indonesia, when you bring private claims to courts, then you will need to prove actual damages. While the violation of the right to personal data protection, well, normally, usually, it doesn't necessarily to have actual damages or material damages. So the damages is significantly immaterial because the violation takes away the fundamental right of the data subject to have control over their own personal data. And this is not necessarily in every case material damages. And also with the private claim procedures, it can be costly and time consuming. So this is not really an effective way of enforcement. And then criminal procedure, it can be problematic because we also do not have enough trainings for enforcers, for courts, and with criminal procedures, we have a different approach. Well, I mentioned earlier with data protection, Personal Data Protection Act, with the idea is to help us to protect our personal data. The idea is not to make people suffer from sanctions. So punishing is another issue. But first, we need people to understand that that personal data protection matters. So criminal procedures have another approach about this. So first, the understanding, and second, the approach is different. So this might not be the effective way of enforcing the law. And we have also another channel by alternative dispute resolution under the PDPA, but this is also problematic because under the with the alternative dispute resolution, it gives us the idea that the data subject is standing equally with data controllers, which is normally not the case. So we have still enforcement issues. Apologize. And last part, it's about security issue. This is a final thought before I give I return to Mbak Shefi. About security issues, yes, the PDPA obliges the data controllers to ensure security of personal data in the processing of personal data. But of course, it doesn't. Well, I say of course because it's not. It is not about security. The act about data protection. So it's supposed to be regulated under a different law. It doesn't mention how to do it. So in practice, then we might rely on standards. We might rely on the EIT law, but we need to think more about how we could solve the security issue and thereby also avoid cases like Pak Boy and Ibu Indri mentioned earlier about data leaks due to security issues. And with that, I end my presentation. Back to you, Mbak Shefi. Thank you very much.
Thank you so much, Bu Yuli, for helping us to spotting out the problem of the implementation of personal data protection. And then you mentioned quite a lot regarding like what is like the some of the problematic provision, or actually not really problematic, but need further guideline or further explanation from the government, and also especially regarding the data protection authority. It's also important because like they will have like some of the quite big responsibilities regarding the supervisory of this personal data protection law implementation. But then we still wait from the government, yes, really regarding this. So we hope that there will be this institution so we can like effectively implement the personal data protection. And thank you so much, Bu Yuli, for the presentation. Thank you so much. And after we hear from Bu Yuli, now we move forward to the presentation or from the speakers from the UK, which we have two speakers from the UK. The first one is Dr. Stefani. Stefani is the academician and also lecturer at the University of Southampton, UK, and she has already had like long experience in personal data protection. And after we hear from the Indonesian perspective, maybe we can hear a lot from you from the UK perspective, like how the challenges in implementing GDPR, and also like how is the important regulation inside the GDPR, also like what is the best practice from there. So we can, as an Indonesian, can also hear from you, and hopefully the government can also like consider the what is it like consider the best practice from you. So the time is yours, Stefan.
Thank you very much. And firstly, I'd just like to say thank you. Thank you so much for the invitation to speak today and to give some thoughts from the European perspective. I'm just looking to check that I can share my screen. 1 second, sorry. I'm just checking I'm sharing the right one, right? You can see the title here.
Yes, we can see that.
Yeah. Great. Okie doke. So it's really interesting to hear from the previous two speakers, particularly because I think it becomes clear that the issues that you're facing with the implementation of your data protection law in Indonesia are very similar, in fact, to some of the challenges that we've identified in the context of the implementation of the GDPR in the European Union and across the EU's member states. One aspect, I suppose, of the GDPR that you've asked us to consider is this broad challenge of implementation, right? Including some of the prerequisites for that effective and complete implementation to ensure the effective and complete protection of personal data. I suppose as a kind of preface, one of the points that I should note is that given the nature of European Union law, given the nature of European Union law and the nature of the legal instrument that the European legislatures have chosen for the purposes of implementing this data protection framework, namely in the form of a regulation. This regulation applies directly in every EU member state, right? So there's no need essentially for different national legal systems to adopt domestic legislation in order to implement that law. Essentially, the purpose of the adoption of the GDPR as a regulation in this form of legal instrument is really to facilitate the uniform application of data protection law across this multiplicity of diverse legal systems. Now, that doesn't necessarily dictate that we don't and we can't identify challenges or problematics with the implementation of that legislation. And certainly in respect of the GDPR, we can. So what I'll do in the next, I think I have 20 minutes or so, right? So what I will do in the next 20 minutes is firstly think about the promise, I suppose, of the regulation. Then think a little bit about the enforcement framework, the essentially procedural law framework that the GDPR seeks to establish. And I will provide a very brief outline of that. As I said, we can identify, similar to the case in Indonesia, we can identify a multiplicity of challenges with the application of the GDPR's provisions to provide for complete and effective protection of personal data. Given the limited time that we have this morning, though, I thought it would be worthwhile to really focus on 4 key issues that have arisen in relation to enforcement. So I'll begin this morning by looking firstly to the promise of the GDPR and the broad framework that it establishes, then looking to the enforcement framework that the GDPR provides for, and then thinking about these challenges and how the European legislator has responded to some of these challenges. You'll see that just to give a brief overview of the slides, you'll see that I've kind of tried to split the slides into 2 parts. So the main points of discussion are in the main part of the slide, and in this yellow box, it's really additional information or reference to certain legislative provisions of the regulation itself. So the GDPR was enacted and came into effect in May of 2018. So it's been in effect essentially for just over 7 years. And the European legislators, the EU broadly, really intended the regulation to broadly as the first kind of comprehensive data protection law of its kind, really to constitute the gold standard, both within the European Union context, but also thinking about this notion of this academic really notion of the Brussels effect of US scholar Anu Bradford. The European legislators, I think, really thought about the scope for the GDPR, or the possibility that the GDPR would have an impact not just within the EU and the EU's member states, but that it might be used as inspiration essentially for and within other national legal systems. So essentially, this notion of the Brussels effect is this idea that European Union law, and we could have a normative discussion as to whether this is correct or not, but this idea that European Union law can have an impact beyond the territorial borders of the EU. Broadly, how is the GDPR structured? So essentially, and very similar, having looked at the Indonesian data protection law, the GDPR establishes data protection principles in Article 5 of the regulation. These principles essentially provide for a set of rules which shape and guide and determine how data can be used, largely by businesses, right? Largely by private actors, but also potentially by public authorities, guiding how this data can be used. So how this data can be collected, how this data can be stored, how this data can be processed, and so on and so forth. The key, arguably overarching principle in Article 5 is that data processing should be lawful, it should be transparent, and it should be fair. We then find in Article 6 of the regulation a number of legal bases. Arguably key is that of the consent of the data subject, a number of legal bases which render that processing of personal data lawful. The regulation then goes on to set out obligations on data controllers, as well as rights for data subjects, right? So both substantive rights, including, amongst others, the right to be informed, the right to the rectification of incorrect personal data, and the right to erasure of that data by a data controller, the so-called right to be forgotten, which was established or recognized as such by the European Court of Justice in its decision of Google Spain that you might be aware of. The regulation also sets out procedural rights for data subjects. Okay, so rights of individuals, but also of groups of individuals or representative groups of individuals to lodge complaints with data protection authorities within national legal systems, and a right of individuals to effective judicial remedies, right? So if we think back to the principles of data protection in Article 5, Article 5.1 sets out the substantive content, essentially, of those principles, shaping, dictating how data should be processed. As I said, the data processing should be lawful, it should be fair, it should be transparent. Those principles also set out, for example, that data should be stored securely, that sets out principles of data minimization, and so on and so forth. But fundamentally, and again, looking at your data protection law, we can see a similar principle, I think in Article 3 of your law. Fundamentally, Article 5.2 of the GDPR sets out that the data controller shall be responsible for and be able to demonstrate compliance with the principles in Article 5.1, right? So we have this principle of accountability in the regulation. What does that entail? Firstly, the data controllers are responsible for compliance with the GDPR, right? That there are obligations as to how data should be processed, and data controllers are responsible for complying with those obligations. And secondly, those data controllers must not only be compliant with the provisions of the regulation, but they also must be able to demonstrate their compliance. So, in terms of its enforcement framework, what does the GDPR provide for if data processing is not done in compliance with the provisions of the regulation? So the GDPR essentially provides for two avenues of enforcement, right? Public and private. On the one hand, it provides that action can be taken by a national supervisory authority, otherwise known as the Data Protection Authority of a member state, or that action can be taken by an individual, or by a representative, or by a group of individuals, or by a representative organization or association, like a data protection charity or NGO. The challenges that I'm going to outline today, I would say really arise in relation to the first avenue. So that action taken by a supervisory authority or by essentially by a data protection authority. So you can see at the side that the GDPR essentially provides for provisions and sets out a framework which establish both the competencies of national data protection authorities and these procedural rights for individuals. In Article 79, the right of an individual or a group of individuals to bring an action before a court vis-a-vis this right to an effective judicial remedy. And in Article 80, scope for representative actions to be brought before a national court, essentially that scope for a data protection charity or NGO to bring an action at representative action on behalf of a group of individuals. Looking to our thinking, I suppose, about the GDPR broadly, I think it's worth noting that the regulation in Europe, the GDPR in and of itself, sits within a broader constitutional and legal framework, right? So when we think about the implementation and enforcement of the GDPR's provisions, we have to think about that within the broader context of legislation that exists, both primary legislation, so treaty legislation and the Charter of Fundamental Rights, and other pieces of secondary legislation, essentially that legislation which aims to establish rights and obligations in various areas of the law. And I'll come back to this a little bit later in my presentation. But it's worth noting, in particular, thinking, and again, I think thinking about what Boy mentioned earlier, thinking about privacy and data protection as relevant to the effectiveness of human rights protection, that the EU's Charter of Fundamental Rights in Article 8 establishes a right to personal data protection. And in particular, in Article 8.3, it establishes that compliance with this charter right to the protection of personal data should be subject to control by an independent authority. Right, so the GDPR then goes on to provide for further conditions for these national data protection authorities. You can see that then data protection authorities within EU member states should be independent. There should be at least one data protection authority in each member state. It's worth noting, some member states like Germany, for example, have a multiplicity of data protection authorities which exist at the state level, so within the German states. Those data protection authorities should be competent to undertake the tasks and exercise the powers attributed to them by the regulation. So what essentially are those tasks and powers? So Article 57 of the GDPR sets out the tasks of the National Data Protection Authority in relation to non-compliance, right? And I've just indicated a couple of the sub-provisions of Article 57 there. Each supervisory authority, each national data protection authority is essentially competent within the territorial scope of its member state. Well, I'll come back to this in a minute. And they should, their key or kind of primary task is to monitor and enforce the application of the regulation. This entails inter alia, that the data protection authority should handle complaints lodged by data subjects or representative organizations, that they should cooperate with, including sharing information and providing assistance to other supervisory authorities in other member states. This is particularly important when it comes to one of the challenges that I will unpack a little bit further, which is cross-border violations of the GDPR. And national data protection authorities should conduct investigations on the application of the regulation, right, for the purposes of its monitoring and enforcement powers. Now, it's worth noting that data protection authorities can act on their own initiative, right? So they engage, for example, in sweeping investigations to identify potential violations of the regulation through the monitoring process. But as I've noted, they can also receive and deal with complaints from individuals or associations. Fundamentally important for the purposes of access to justice is that national data protection associations, authorities, should be free to use as a general rule. If we look to the further provisions of the regulation, then data protection authorities have, and the GDPR sets out the powers that those data protection authorities have. So key really are the investigatory and corrective powers of those authorities. And I've just listed the investigatory and corrective powers attributed under the GDPR to these regulations, right? So attributed to these authorities. And you can see that they're quite extensive, both on the investigation side of things and in relation to the sanctions that DPAs can issue. A lot of discussion has really focused on the imposition of administrative fines by national data protection authorities. Some of these fines are, huge fines, particularly in the context of cross-border violations, so violations of the GDPR that affect data subjects in a number of EU member states. It's worth noting that the DPAs should operate. So there are procedural essentially protections that the DPAs should operate in line with procedural safeguards, including the right of a individual to an effective judicial remedy and due process, which also extends to the data controller, right? So the decisions of national data protection authorities can be challenged before national courts. Data protection authorities themselves also have the power to bring proceedings before national courts. So notwithstanding that we have this decentralized enforcement framework, essentially, which attributes the primary tasks in relation to enforcement to generally administrative regulatory authorities within national legal systems, the national courts still have a key role to play, potentially also in relation to the review of the decisions of those DPAs. As I said, much of the discussion in relation to the GDPR and its effective enforcement has centered on the imposition of fines, which should be effective, proportionate, and dissuasive vis-a-vis the data controller on whom they are imposed. But you can see that the GDPR essentially establishes a bit of a hierarchy. So there are two levels of fine, really depending on the provisions violated and the determination of the level of severity of the regulation. Now, as I said, data protection authorities are generally competent territorially. So either they launch an investigation into a data controller having its main establishment in their member states, or an individual can make a complaint to the data protection authority of the legal system in which they're habitually resident. But some of the key challenges with the GDPR arise where a violation cuts across national legal borders, right? Where there's cross-border data processing, which generates a violation of the GDPR and which impacts and potentially damages data subjects resident in a multiplicity of member states. The GDPR establishes a procedural framework for this, known as the one-stop shop mechanism. Essentially, the data protection authority in the member state in which the data controller has its main or primary establishment will be competent to lead that investigation and to render a binding decision on it in collaboration with other interested data protection authorities. Now, as I said, I've identified 4 kind of key challenges, and I will then very briefly speak to the responses or the solutions, essentially, that the European legislature has attempted to identify to these challenges. The first is the issue, essentially, of decentralized enforcement. And decentralized enforcement, I think, really leads to lengthy and inconsistent enforcement, particularly in the case of cross-border infringements of the GDPR. The burden of enforcement lies with the lead data protection authority, that data protection authority in which large controllers are established, right? In the context of the EU, this generally, we can look to kind of 3 or 4 member states, Ireland and Luxembourg predominantly, in which companies like Meta and Amazon and Google have their main establishment. This essentially means that the Irish Data Protection Authority has a huge burden in terms of dealing with complaints, and you can see some of the data on the side of the screen there. What does this lead to? Well, it leads essentially to 2 problems. The first is the amount of time that it takes to deal with a complaint, right? The GDPR requires that the lead data protection authority renders a draft decision without delay. but some complaints have taken more than 4 years to resolve, right? There's still some complaints which were brought in 2018, which still have not been resolved by the Irish Data Protection Authority. So this issue of lengthy enforcement proceedings is really problematic. The second issue related, or the second, I suppose, sub-issue is that the scope for effective enforcement is really linked to the resources of national data protection authorities, which differs across European Union member states, right? If we look, for example, to Germany, there are more than 1,000 staff working in the data protection authorities in Germany, versus only around 50 staff in Romania and Croatia. Relatedly, there is an issue. So I noted earlier that data protection authorities should be independent. There is an issue, I think, with the political influence of data protection authorities potentially, or at least the impression of political influence in countries like Ireland, right? There's a reason why Meta is established in Ireland, mostly relating to tax benefits that they obtain there. And there's a question as to whether the Irish Data Protection Commission can really deal with, and whether there is a degree potentially of political influence in terms of their complaints handling process. Now, in response to this issue, the Commission has taken has adopted one solution, which is that the European Commission will now monitor all large-scale cross-border complaints, right? So there is a degree of kind of oversight in how those complaints are handled, predominantly to ensure that the proceedings are less lengthy in their time. There's a second challenge, which is what, in particular in cross-border complaints, what if a data protection authority cannot reach consensus on an outcome in relation to a GDPR infringement? The regulation establishes cooperation obligations on lead and interested DPAs, right? So, for example, Ireland is the lead DPA, France, Italy, Germany, Slovenia as interested DPAs. In this instance, there is an oversight body, essentially the European Data Protection Board. An oversight body is not quite the right term, but the European Data Protection Board, if interested in lead DPAs cannot come to a consensus on the outcome of an investigation, that board will render a binding decision. Now, there is a question currently before the European Court of Justice on the scope for judicial reviews of draft decisions in complex composite procedures, right, where both national and supranational actors are involved. The third issue, and I think Napoleon will talk to this a little bit as well, is the fragmentation of enforcement amongst various national regulatory authorities. As I said, the GDPR has to be seen in the context of the entire EU's legislative framework, right? Particularly in relation to the regulation of the digital space. In recent years, we've had a number of new pieces of Act, the Data Governance Act, and so on and so forth. The of enforcement mechanisms and safeguards, but there's still a great deal of uncertainty in relation to the allocation and distribution of powers and competencies, right, which generates the scope for institutional conflicts between supervisory authorities under the GDPR and under each of these additional pieces of regulation, which has the scope to undermine effectiveness of data protection. In the absence of clarity, legislative clarity, the European Court of Justice has taken a role to try to develop a coordination procedure in light of a kind of key principle of EU law, which is that of sincere cooperation. But what we see is that as the EU continues to regulate for the digital space, we will need to engage in this type of mapping that was mentioned earlier, right? This kind of identification of a roadmap. And this hasn't yet been done, right? So this broad coordination mechanism identified by the Court of Justice really isn't enough. We need, I think, a legislative framework that determines how different institutions should cooperate with each other. Finally, and I think this was mentioned earlier, so I can be very brief on this, there are considerable challenges, compliance costs essentially for small and medium-sized enterprises, particularly in terms of reporting obligations. And the key challenge is that, or the key kind of perceived challenge, is that these obligations on smaller companies disproportionately burden those companies, right? Where large multinational, transnational private actors like Meta have the resources to try to comply with the GDPR. The resources of these smaller companies obviously are much lesser. There's a broad challenge that this is deemed to undermine innovation and economic growth in the EU. So there's a proposal for a new regulation simplifying the GDPR, particularly reporting requirements for small and medium-sized enterprises. I won't go into this in too much detail, but it's been a legislative development which has been identified as necessary. I think there is a danger that this simplification of obligations on the part of certain data controllers is simply another term for deregulation to a certain extent, right? And there's a challenge there that this simplification potentially undermines the individual's rights to effective data protection. And I think we can see this deregulation trend more broadly in the European Union context. Some reflections on enforcement, and I promise I will stop talking. So I think it's clear that the GDPR has had an impact on the protection of personal data, right? Some of which are clear, let's say, on the basis of changing practices of generally transnational companies, right? Like Facebook, like Meta, like Instagram, and so on and so forth, where they have in fact changed their terms and conditions to ensure compliance with the regulation. So we can see some key impacts that are observable through findings of infringements by data protection authorities. Others, I think, are rather more hidden, right? They exist kind of behind the law. So nudges to changes in the behavior of data controllers, including the resources that they allocate to the protection of data. And increased awareness, and I think this is really key, right? This has been mentioned previously. Increased awareness of individual privacy rights is really, really fundamental. This idea of digital and data literacy is key. What's become really clear in the context of the EU is that there's a need to combine substantive rights with cooperative and coherent procedural mechanisms, right? These procedural mechanisms really were lacking, I think, when the GDPR was first implemented. And it's clear that the EU has taken some measures to improve them. One such measure is this proposal for regulation setting out procedural rules relating to enforcement. And you can see essentially what this regulation aims to do. As I said, I think one of the broader challenges is this emergence of a regime of digital regulation, right, in which the GDPR plays a key part. And I think we need to engage in this road mapping to facilitate firstly the coordination and cooperation of different supervisory authorities under different pieces of legislation. Potentially, I think a need for a shift from this largely decentralized mechanism of enforcement to some centralized enforcement, potentially an increased role for supranational actors in oversight. Thank you very much. I've put my email address on the screen, and please do let me know if you have any questions, and don't hesitate to send me an email if there was anything at all that interested you. Thanks again.
Thank you so much, Stephanie, for sharing like from the perspective of GDPR. And it's clear that we are also like have similar challenges in implementing the personal data protection law, but then like Yes, maybe like there are some of the specific condition, the difference of the condition in EU, UK, also Indonesia, but we are quite like in the same page for some of the issues on this. For example, regarding the medium and small enterprises, because Bu Yuli also mentioned about that, and then like Stephanie also mentioned about this, it shows that there is a similar problem on that. Thank you so much once again, Stephanie, for the presentation. And the last speaker, we will invite Napoleon Xanthoulis, which is also an academician from the University of Southampton. And maybe Napoleon can share more regarding like the GDPR perspective and also like can complete the presentation that is already presented by Dr. Stephen. The time is yours, Napoleon.
Thank you so much. Thank you for the invitation, and both to Paham Hukum for organizing this conference, and to Boy and Yusef Vieira for hosting us. Before I begin, I was just wondering how many minutes do I have, because I'm mindful of the time.
Yes, it seems that we've exceeded the time, but is it okay if like we reduce to 15 minutes, Napoleon?
Sure,
So you
absolutely.
can, so we can finish at 4 p.m. Indonesian time, and we will continue to the 15 minutes Q&A.
Absolutely. Let me start by saying that I was quite impressed when I was listening to the speakers from Indonesia, both the government representative and our fellow academic, because I felt that I was actually reading a design of data protection law that looks almost identical to the one that we apply in the United Kingdom and the European Union. And echoing what Stephanie said a minute ago, many of the challenges and the issue that trouble both policymakers as well as academic scholars seem to be very similar, if not identical, to the challenges that we are currently discussing in another part of the world. So it's nice to hear that we may be geographically far apart, but our minds are concentrated on very similar issues. But I would like to perhaps focus this presentation somewhere else, because so far we've been discussing on data protection, and the title of my presentation is From Data Protection to Data Governance, which implies that maybe data protection is no longer enough, or no longer a useful way of thinking about regulating data, which is a bit bizarre, because the whole point of this conference is that the word is data protection law. So I'll try to make the case that maybe we need to start contemplating the idea that data can be protected may no longer be feasible. And to do that, I'll try to bring the idea that we are currently living in a digital world which has forced a revolution in the way we perceive privacy. Every aspect of human activity is currently quantified in data. All digital systems are currently communicating with each other. Internet of Things was also mentioned by one of the previous speakers. There is huge amount of online surveillance, both by private actors and public actors. Our activities are profiled by automated systems that create profiles and patterns about behavior and are able to predict our future choices, whether these choices are commercial, whether these choices are political. There is increased monitoring of the working environment. We have new types of data being used, including biometric data. We have location data. And of course, we have the emergence of big data and huge databases that are currently training all AI systems, such as ChatGPT systems based on machine learning and large language models. And of course, we have globalization. Everything is immediately accessed from every single part of the world. Our current conference is the basic proof that globalization has allowed 160 individuals to come together and discuss extremely complex matter as if we were in the same room. But the same applies for our own personal data. Just to illustrate this a bit further, we used to consider a car as a metal box on wheels, and now cars are increasingly becoming computers, robots on wheels. The car records the music that we like, it listens to our conversations, the seats can track our weight, they can record where we go, how long we stay, and all this data can be shared with third parties, not only the manufacturer of the car. The same applies for our phone devices. We used to have simple phones to make phone calls and perhaps exchange messages. But now maybe we have a spy in our pocket with our phone and maybe our watch. Some of you are already wearing some watches, are able to track our steps and map our movements. They know our calendar. They know what books we read and what movies and TV series we like. And we have an enormous development of location data, and that location data is not innocent. The knowledge of where we are and how long we spend there can be used to draw very important inferences about who we are. It can allow someone to figure out the address of our home or where we work. Whom do we meet? Do we meet people of importance, of public importance? What is our social circle? What religion we believe if we visit certain churches or mosques? Perhaps we are spending some time in a therapist's office and we're undergoing therapy. So by disclosing our location data, we are not just disclosing our movements, we're disclosing substantial, essential, perhaps sensitive information about ourselves. But maybe the fear that is not as strong because these are just technological means that can be used neutrally. But I would argue the opposite. I would argue that there is no such thing as neutral technology. Everything that human beings create comes with certain potential. In the same way, you can create a knife. That knife, of course, can be used to cut bread, but can also be used to harm someone else. Yet the very existence of a knife comes with certain risks in the world. So my argument is that the mere existence of digital tools, our digital phones, our laptops, our AI systems create new risks in this world for our privacy, for our data, for our freedom, for our ability to enjoy an autonomous and fulfilling life. So the mere existence of these new technologies come with risks that cannot be ignored, I would like to argue. But where are we now? How is technology revolutionizing data? For the first time in human history, we're using all the data. We don't select the data that we use. Our machines are recording every single piece of information that is generated by our activity. And at the same time, we use the same data for an enormous amount of purposes. In the past, we used to collect data to conduct an experiment or to collect data, let's say, to figure out whether people are happy for a specific policy of the government or for a specific product. Now we gather data that can be used over time for purposes that perhaps were different for the original purpose for which they were collected. So what am I arguing here? Am I arguing that privacy is dead? And perhaps there are two arguments here. The first one is that perhaps privacy is not really feasible in our digital ecosystem. The data is no longer in our control. There is an illusion that we can maintain sufficient control over our personal information. The second potential argument is that, well, even if we could exercise control over our personal data, perhaps this is not desirable Maybe the benefits of allowing free flow of information exceeds any risks to our privacy. Well, maybe there are other public interest values that override our privacy. Maybe the value of creating a global society, maybe the value of having easy access to digital products, the value of just clicking a couple of times on your phone and having a meal at your home, or having access to all sorts of products and information online, or communicate with your friends very easily, or get advice and recommendations that are tailor-made to your own preferences. Do we really care about privacy today? If we ask individuals, are they really willing to pay the price of protecting their privacy, or do they see privacy as a less significant value in comparison to all the time that is saved by having tailor-made experiences in the virtual world and in social media? I would argue that although there's a perception that privacy is lost, I think there is a lot to be done to protect privacy. But the European Union increasingly realizes that personal data in itself is no longer the solution to maintain an efficient regulation of our privacy sphere. And here I'm listing in this slide a few regulatory attempts that try to complement the data protection regime. Stephanie, I think, gave a wonderful overview of some of the key features of the EU's General Data Protection Regulation. And I'm really pleased to see that there is really a Brussels effect here going on, where the design, the blueprint, the underlying objectives of the general data protection in the EU seems to have somehow influenced the Indonesian legal reform. And the European Union was the first ever jurisdiction to really try to create a comprehensive system of personal data. But increasingly we realize that this is insufficient, and it's insufficient for a number of reasons. Well, first of all, we're wondering whether personal data has a meaningful definition. Personal data that is not personal in the hands of someone, it can easily become personal in the hands of someone else, depending on the knowledge that they have. Pseudonymous data can be combined with other information and can easily lead to personal data. Anonymous data can be processed through AI systems and become de-anonymized, therefore creating new personal data. So maybe the idea that we should have a distinction between personal data and non-personal data and try to apply a regulation purely for personal data increasingly becomes non-feasible. So we've started moving into this idea that we should no longer try to protect data, and particularly personal data, but we're moving towards the idea that we should try to regulate data holistically, irrespective of whether this is personal data or not. And that's why we have, as Stephanie signaled, new regulations emerging. The first one is the Data Act, which suggests that instead of trying to protect data, we should simply create rules and conditions and safeguards on how, who, and when, and under what conditions data can be shared and reused, both between businesses as well as between businesses and public institutions. Then we have the Data Governance Act, which creates new rules on the conditions that would allow public government institutions to share and perhaps reuse for different purposes existing data. We have the Digital Services Act, which is the first comprehensive framework that would try to regulate big tech, try to create new obligations, new transparency requirements, new procedural rules that would allow to hold social media and search engines and the like accountable due to their ability to really have an immense influence into our personal privacy. We have the Digital Markets Act, which focuses on regulating the market power of some of the bigger online platforms. Of course, we have now the new Artificial Intelligence Act, the first ever comprehensive law on the development and use of AI systems. And now we have an intersection between AI and data. And we have the European Chips Act, which tries to create digital sovereignty on the hardware that would be used to process data, and the Media Freedom Act that tries to create new rules on media freedom, pluralism, and editorial independence. Perhaps a word about the influence of GDPR in companies outside the European Union. Now, although GDPR aims to, in the first place, to regulate the conduct of companies that are based in the European Union, in fact, it covers also the processing of personal data, of data subjects who are in the Union, but by a business, a controller or a processor, in other words, who is not necessarily established in the Union. So it covers also businesses based in Indonesia, businesses that are either offering goods or services, or businesses that monitor the behavior of EU citizens. So an Indonesian company that wishes to conduct business by offering services or goods in the European Union is bound to comply with EU GDPR. I'm mindful of the time, so I'll just focus on 2 points. The first one is that the intersection of AI and personal data. The relationship between personal data and AI is what I call a two-way street. Data is used to feed, it's the lifeblood of artificial intelligence systems. At the same time, data is exactly the output of an AI system processing. So we give data to an AI system, something happens in between, and what the output becomes also data. And now we have a third dimension, which is to what extent the data that is produced by an AI system has the capacity to really predict and perhaps influence, shape our own human decision making. And that's particularly relevant with respect to profiling, purely automated systems and processes that create predictions about what we can do in our work, what we can afford financially, what would be our future health prospects, what our personal preferences, interests, where we're likely to go, with whom we're likely to socialize. I'm mindful of time, so I'll finish with a final slide. What are we facing at the moment in the European Union? We're facing with a struggle on keeping a meaningful distinction between personal data and non-personal data. We increasingly realize that this distinction is not enough to grant sufficient protection. That is because we have anonymous data being de-anonymized, pseudonymous data being very easily purely personal data. We increasingly get the thought that maybe we need to move from a risk-based approach, which would focus primarily on preventing someone from having access or controlling the piece of information from going somewhere else, to a harm-based approach. In other words, asking not who has access to what kind of data, but what is the harm that may be caused by allowing this data to be accessed by third parties? What is really the damage and the infliction on an individual right and interest? It is time to rethink the function and purpose of consent. It's the consent, I think, feeds the idea that we can, by consenting to the release of personal information, we magically somehow make everything lawful. But consent is perhaps not meaningful, not essential, and not appropriate in a world of or in a digital ecosystem where we're just clicking buttons, consenting to the release of our personal data without really any meaningful thought about the impact that it would have. So a few more issues concerns the international data transfers, what happens to our data when they move territory. I think some of the questions in the chat room touched about that as well. The overlapping regulatory frameworks that Stephanie already has raised that creates a very confusing ecosystem of regulations that is very difficult to comprehend both by data processors and controllers, but also by policymakers. And which leads to a knowledge gap where we feel that we don't know enough, yet we're very happy to regulate quite significantly. And perhaps the fact that we end up in an over-regulation space has led to some thoughts on perhaps simplifying some of these regulations to create more realistically feasible obligations for small enterprises, yet nevertheless leading to the risk, as Stephanie said, of deregulation, of essentially not really simplifying our rules, but perhaps losing some of our rules that benefits the weaker parts of the society, the data subjects, the individuals, us, in other words. Thank you so much. It's been a pleasure, and would love to hear from you, and would love also to receive any communications you may have in the future if you find any interest. Thank you.
Thank you so much, Napoleon, for the important presentation regarding like how the implementation of GDPR itself, and also like the challenges of the implementation, and also like how is like the future implementation of this, because we know that the digitalization issue is very fast growing. We know that there is the issue of AI, the new technology things. So there should be a contextualization between this personal data protection law with the new technology. Thank you so much for that. And I am aware of the time. I hope that we can finish this international seminar at 15 past 4. So I am so sorry for the participant. Maybe there will not be enough time for us to discuss further, but I invite for about like 2 or 3 questions, and then like all speakers can respond to this. The first one, because like there are already many questions in chat room, I want to invite, the first one is Nella Octaviani. Could you please to deliver your question directly if you are available? Nella Octaviani? Okay. Maybe I will move forward because the time is very limited. I will... Hello?
Hello, Assalamualaikum. Hello.
Hello? Is this... Okay. So Nella is available. Yeah. Can you please share the question, Miss Nella?
Okay, the question is about, can you hear my voice?
We hear, but it's not that clear.
Because this is the connection here is unstable. Maybe
Okay, is it okay if I move forward to other participant?
yeah.
Okay. Okay then, yeah. Maybe the connection is not that good. Okay. Because there are several people that has already raised hand. I will invite Faisal Lillah because he already like sent many question in the chat. Maybe you can like deliver your questions.
Halo, Assalamualaikum.
Waalaikumsalam.
Let me introduce myself. My name is Faisalillah, Law Selatan Slamet Sri Kendal University. I would like to ask about the PDP law and the legal basic for personal data protection, gitu kan. Tadi ya, international personal data protection crime and highly complex because they involve different jurisdiction law and often actor operation across national border. Question: what makes personal data protection crime a transnational issue? Example: hacking of server in one country by actor in another country, selling that on the dark web globally. Two, what are the main challenges in identifying, tracking, and proceduring representation of personal death crime operation in different confident. Thank you.
Okay, thank you so much. So maybe the question is more about the cross-border data flows, especially on the criminal data. So if I'm not mistaken, if I got the question, but if you really have like other understanding on the question, maybe you can explore on this. Okay, yeah. Okay.
Okay. Okay. Thank you, Mas Shafi and Mas Faisal. I'll try to respond quickly if I understand correctly. The answer, the question is about it's about the criminal aspects of data protection. Yeah, so it's about the criminal enforcement of data protection. If it's about Data Protection Act in Indonesia, I would say, first of all, not every country qualifies the violation of Data Protection Act in their country as criminal infringement. So maybe Stephanie and Napoleon, if I may, you can also say, but I believe GDPR is not about criminal enforcement. So if you violate the GDPR, it is not a criminal act. And in Indonesia, we formulated as one of the violation is a criminal violation under Article 67. And so responding also to I think to your question in the box, and now about how to enforce it. Well, this is well, it's a $1 million dollar question, because for the enforcement, if we haven't even talked about the enforcement in Indonesia itself. So this is already a challenge. And if we talk about the cross-border enforcement, then this is the next level issue. But what I imagine is that we need to have cooperation, so international cooperation with other countries, namely that we have cooperation among law enforcers with other countries. So this is something that we need to work on, and this is a little framework. Maybe there's something in the next step. But first of all, we need to deal with how we enforce it in Indonesia. And about the hacking, well, the hacking itself, not per se violation of data protection. It has the impact on the violation of data protection, but you have other issues in the action of hacking. So in Indonesia, then you will have also to deal with the Electronic Information and Transaction Act. So the IET law under law number 11 2008 that recently amended under law number 1 of 2024. So you have there. So it's not it's the hacking itself. It's not a violation of data protection. Well, the illegal collection of data protection, for example, yes, it is a violation of data protection. for the interest of time, maybe so far I can respond. But Shefi, I hope it answered the question. Thank you so much.
Yes, thank you so much for that, Bu Yuli. Maybe we can go forward to another question. There is already like two people raise hand. Maybe Laura can share the question to us.
Okay. Can my voice heard it?
What did you just say? Sorry.
My voice heard it.
Yes. We can hear your voice clearly.
Thank you. Thank you for the opportunity. Personally, my name was Laura, one a fellowship for Paham Hukum, the Community Affairs Division, and I will like to ask a question as well. Although the rapid development AI is increasingly being applied in various sector. Another example is a trend at TikTok, including personal photo edits, such as those trending on the TikTok using AI tools. To another example is review document like CV private in AI, or in the example is in GPT, and even the emerging idea of the recruitment process conducted by a basic hearing resource or HRD in their system. And in this context, how does all speakers can answer in my question? This question speaker feel the relationship between these AI-driven deployments and the particular of the personal data protection in the legal frameworks, and are the current regulations applicable to address this challenge, particularly regarding the automated discussion, making the cause significant impact to the rights data subject? That's my question is. Thank you.
So is it like the main question is about the personal data protection relation with the AI trend in TikTok, Laura?
Yes, and
Okay.
sample is like a document CV. Somehow, many people make the ChatGPT for the review CV personal.
Yeah,
like that.
yeah. Okay, thank you so much for the question. So maybe like this question is for Napoleon, because like you have presented to us like how the personal data protection law interact with the issue of AI. So maybe you can respond to this question.
Sure. It's a wonderful question, actually, and I'm really pleased that you've already started thinking about this, because it troubles us a lot. So what obligations do data controllers and data processors have in respect of using personal data to train AI systems? And the answer to that is that according to the EU's GDPR, if any information, any personal data that you upload may be used for training purposes, the data controller has a duty to ask permission, to ask for consent to use this data for training purposes. Very often, this would be in a very tiny little letters in a very long document that you just click consent when you enter into an application, and you barely notice that you've ever done it, which brings a question as to the meaningfulness of consent. But the first obligation is that they would need to acquire your consent before they use the personal data to train the AI system. The second obligation is that if you are experiencing a service which involves the use of automated decision making, now under the GDPR and the new AI Act, the data controller has a duty to disclose to you that part of the information you received is the product, is the recommendation of the use of an AI system. And under certain conditions, you could, under the GDPR, prevent or reject or any recommendation based on purely automated decision-making process. But you also have the capacity to consent to it as well. The the regulation now is moving towards a direction where if a company is using an AI system to produce an output, let's say to recommend you a movie, to recommend you a song, or to recommend you a product, they would have to disclose that these recommendations are not accidental, but they are the product of an algorithmic process. So we're going into a duty to be informed, transparency-related obligations, and depending on the risks that the AI systems have in our lives, that the transparency obligations may be different. In cases where a decision is made that affects your life based on purely automated processes, we now have the emergence of the right to an explanation. So where an individual has the right, the legitimate expectation to be able to understand both the decision that was produced through an automated process as well as the reasons that motivate that decision. Why didn't you allow me to have a bank loan? Why did you reject my application? And the reason we need these explanations is both because they are essential to be able to challenge the legality, the lawfulness of that decision, but also for intrinsic reasons, because if a decision is unjustified or impossible to justify through individual means, then it's arbitrary. It really prevents an environment where we treat each other with basic human dignity.
Okay. Thank you so much, Napoleon. And maybe this is the last one from Amorita.
All right. Am I audible?
Yes, you're audible.
Okay. Thank you so much, firstly, because of the really insightful materials from the speakers. So, let me drop the question on the comment section. Okay. So, essentially, there's a couple of questions that I would like to ask. Firstly, is about how the regulation of a data controller and data processor in a different country and jurisdiction. Suppose an Indonesian company acting as the data controller that collects personal data from Indonesian citizens, but then transfer that data to its partner, a German company, which is subject to the GDPR, of course, and for the purpose of applying the AI for the data from the Indonesian company. I would like to ask, in that scenario, does the German company needs to comply with the GDPR regulation, or the GDPR only applies if the subject of the data is an EU citizen? And maybe for my second question, probably is about we know about the technological advancement. One of it is mentioned about blockchain. So I actually have a case that's about blockchain, but one of the main argument itself is about how blockchain have the nature of immutability, immutable nature, which means that once the data is read and it cannot be altered or deleted. Correct me if I'm wrong. So I would like to know, because on the GDPR and on Indonesia PGP law, it has the data subjects a right to erasure or the right to be forgotten. How does data protection laws can accommodate this new technology? Or is there any possibilities for blockchains to be implemented, or like it's just not possible? I think that's for my two questions. Thank you.
Thank you so much, Amorita. Maybe the first one can be answered by Stephanie regarding the regulation of controller and processor in different country and jurisdiction.
Yeah, thanks for your question. I already tried to answer it in the chat because I saw that you put it earlier. And I think Napoleon explained it quite well, because he spoke about the essentially territorial or potentially extraterritorial effect of the GDPR. So the regulation applies to provide protection to not only citizens, it's important to say, but data subjects who are within the territory of the EU member states, right? So it affords protection, I think, to a broader body than just EU citizens. but all data subjects are within the territory of the EU member states. And it also applies to data controllers and processors who are both those who are established within EU member states, but also data controllers and processors who are established outside of the territory of the EU, but essentially who target EU-based data subjects, right? So it's the scope of the regulation. I wouldn't say it's extraterritorial necessarily in the sense that we traditionally in public international law terms think about extraterritoriality, but it has a broad scope of application. I think the interesting aspect of your question is so the transfer, the GDPR then would definitely apply to the German data controller, right? And the challenge, I suppose, in your question is that personal data of the Indonesian citizens would more than likely be mixed with personal data of EU-based citizens, right? So it becomes difficult to distinguish the personal data of residents or data subjects in different jurisdictions. More than likely, the GDPR would apply to the German data controllers or data processors processing as a whole in this situation, right? On the second question on the blockchain issue, I mean, I think that's a pretty considerable set of challenges, right? I think it's worth noting. I mean, I think that there's a general, let's say, guidance that personal data should not be stored on a blockchain. There are provisions in the GDPR, which I don't think we necessarily have time to go into now, concerning the pseudonymization or anonymization of personal data in certain contexts, which then takes essentially the protection of that personal data outside of the scope of the GDPR because it cannot be essentially connected to a particular individual. But I mean, I think that's what I would say for both questions. I put a bit more detail in the chat on your first question in any case.
Thank you, Stephanie. And for the second question, Windri, could you please add some of the context of Indonesia? And also there is a question in the chat regarding do we also have to consider that government readiness to implement personal data protection is also a challenge in implementing this personal data protection law exactly? You're still mute, Windri.
So thank you, Mbak Sevi, for try to raise these issues. I believe, first of all, we need to realize that one of the biggest data collector in the countries, like Indonesia, is public institutions or let's say government-related institutions. So the issues of government readiness is, for me, is a big issues or a key issues. In certain extent, it's actually greater than when we see the readiness of the private sector, simply because for a private sector, depending on the size of and the scale of the companies, some are actually engaging and try to work with the similar standard applied globally, like the EU GDPR, because of their operations. But with regard to government institutions, the issues of the standard applied for the data collection and data processing of their citizens may seem still be scattered across different institutions with a different standard. What makes it worse, from my view, is the fact that we are dealing with the silo operation of each institution. So, in that regard, I believe we should really consider the readiness of government institution as one of the challenge to have and to implement the protection as contained in the PDP law. Yet, as you also may notice, that at the implementing regulations, recently the Ministry of Communication and Digital has already issued a ministerial regulation that provide obligation and oblige all the private all the public institutions to also start to comply with the standard as provided by the PDP laws when it comes to processing and the collection of personal data of the citizen for the public services. It is enacted in 2025, just recently, a few months ago, in February, under the Ministerial Regulation number 5, 2024. And in that, we also see that there is also, it contains of several administrative sanctions provided for those government institutions that actually fail to comply with that standard within a period of time, a certain period of time as contained in that. So that's my view on that. Thank you.
Thank you so much, Windri. By that, we actually like in the end of this international conference, and we are very grateful for each of the speaker for sharing like all the materials and so like the knowledge and also like the perspective on the personal data protection implementation, whether in Indonesia, EU, and also UK. And for the very last thing, the committee really want to like capture like each of the page of this Zoom. So maybe like if each of you are able to open up the camera and are consent for this, you guys can open that. But then if you have the problem or issue with internet connection or not really consent with this thing, you can still like just turn off your camera. So maybe the committee can screen cap the Zoom meeting. Okay, 1, 2, 3. Okay, the second page. 1, 2, 3. Okay, and then the third page. The fourth page. And the last page. Okay, thank you so much, everyone, the speaker, the participants that have already joined this international conference. We are super sorry with the time because we supposedly like finish this discussion in 4 p.m. But then like there is time exceeded with just like 30 minutes. We are very sorry for that. And for the further information regarding this seminar, for example, like the certificate, also like the recording, the committee will give the information through the WhatsApp group. So thank you so much for today's discussion. It's very important for us to discuss this and still need more time to discuss this because it's very, like broad issue. And then like, especially when we try to put Indonesia, UK, EU in one plate, that for sure we need like a very long time. So thank you so much, Bu Yuli, Bu Indri, Stephanie, also Napoleon for the discussion. And for sure, see you in other occasions, whether by Paham Hukum or any other occasion. Thank you so much and stay healthy, everyone. Thank you for the participation. Thank you.
Thank you.
Thank you.
Thank you. Thank you
Have
so
a
much.
nice weekend. Bye.
Thank you.
Every night I lie in bed, the brightest colors fill my head. A million dreams are keeping me awake. I think of what the world could be, a vision of the one I see. A million dreams is all it's gonna take. Oh, a million dreams for the world we're gonna make. There's a house we can build. Every room inside is filled with things from far away. Special things I compile, each one there to make you smile on a rainy day. They can say it all sounds crazy. They can say we've lost our minds. I don't care if they call us crazy. Run away to a world that we design.
Every night I lie in bed, the brightest colors fill my head, a million dreams keeping me awake. I think of what the world could be, a vision of the one I see. A million dreams is all it's gonna take.